think we have a perfect topic tonight. I won't get into introductions, but a topic tonight that exemplifies that none of our ways of studying religion are innocent or without complications. And the fact that we can have this conversation in this room is a wonderful event. So I look forward, I'm very glad that everyone is here tonight, and I know that in the future we'll have more such co-sponsored events and creative ways of carrying on the conversations across the way here. So I say thank you and welcome.
Thank you so much, Frank. It's, I said to Frank that I almost didn't feel like we need a welcome because we feel so at home here in the Women's Studies program, but it's a wonderful collaboration and we're very grateful to be here. We are cramming 4 lectures into the busy spring term, so we're delighted to see you here today, and we will reconvene a week from today for Shang Mi's lecture on women in literature in nationalist China. But today we're very happy to welcome Yüksel Sezgin. Yüksel is trained in political science, but as you will see, is a broad comparativist and a very broad thinker. He has his comparative topic reflects his background and his training. While he did his PhD in political science and public law at the University of Washington, he holds a BA in international relations and law from the University of Ankara in his native Turkey, but also masters in Near and Middle Eastern Studies from both the University of London and from Hebrew University in Jerusalem. Before joining us here, he taught at the University of Washington, and he has a permanent appointment at the City. I was going to say the City University of New York, but that's
yes,
right.
It is.
That's
yes,
right.
yes.
Thank you. Good. Thank you. One of the things that is very engaging for us about Yüksel's work is his ability to bridge the academic and the practical arenas. He serves as a consultant for UNIFEM, the United Nations Development Fund for Women, and he's been an important part of the report that they are about to bring out, which will be the first report of the new UN Women, the new umbrella organization focusing on women's welfare internationally. He has edited a special edition of the journal Religions, a special edition of the Journal of Legal Pluralism, a topic that he is educating me on, that I'm just starting to learn about, focusing specifically on religious and customary law and women's rights. And he's really one of the foremost voices in this arena, so we're delighted to have him here today.
Thank you. Thank you.
I'm just going to pick this up while you start.
Yeah. Okay, please go ahead. This has been so far one of the most productive and intellectually stimulating years of my life. And I'm particularly indebted for this to Dean Graham, and Braude, and my fellow faculty members at Harvard Divinity School who has given me this opportunity this year, very privileged opportunity to be here this year. I'm indebted for that. Also like to thank my fellow associates at WSRP and our staff members, Jacob and Catherine, who has turned the Carriage House into a 24/7 house of scholarship and learning. And I also like to welcome you and thank you for joining us in such a beautiful day here. I think it looks like we're in competition against Vice President of Malawi tonight, so thank you very much. It's a great honor to have you here. Let me say just a couple narratives. Let me share a couple narratives with you before I start my presentation. I'm hoping that those narratives will help me contextualize the topic that I'm going to talk about tonight here. Let me check if this is working. Yes, it is. All right. Resham. Resham Bibi is a Muslim woman. She's from India. And one day she comes to the court and she says, I have renounced Islam. I no longer believe in Prophet Muhammad or Quran or Hadith or the source of Islamic Sharia. And based upon that fact, she asked the judge to dissolve her marriage from her Muslim husband. This is because, according to Islamic law, apostasy or renunciation of Islam renders the marriage of a Muslim null and void. Based upon that fact, basically, she was asking the judge to annul her marriage. Of course, the public prosecutor has to test her disbelief in Islam. He had another option, basically, like in another liberal democratic country. If anybody makes a claim about her personal convictions, she will basically take that at its face value. But what the prosecutor in India did, he ordered a plate of pork to the courtroom and asked Gresham to take a bite. When she refused to comply with the request, the judge ruled that her conversion was insincere, basically rejected her request to be separated from her husband. Similarly, Hala Sıtkı is a Coptic Orthodox actress from Egypt. She's very famous, well known in Egypt. And she fought a legal battle for almost about a decade to divorce from her husband. But unfortunately, she was not able to get a divorce for almost a decade. But she had a very clever lawyer. And the lawyer found, and this is perhaps why you pay lawyers, right? So the lawyer found a very clever loophole within the system, according to which it said, when a Christian couple, basically when Christian spouses belong to different churches or denominations, they are subject to not Christian law, but Islamic law. So what she did, while her husband remained a Coptic Orthodox, she changed her denomination to Syriac Orthodox, and by doing so, she was able to obtain divorce under Islamic law. Nikolai was 23 years old when he died in South Lebanon. He was killed by Hezbollah in an ambush in February or March 1998. Like all other, from the Israeli point of view, of course, like all other fallen heroes, Nikolai was a martyr. So there was an official ceremony in order, and all 4-star generals and the higher echelons of the state was supposed to attend the ceremony. But at the very last minute, rabbinical authorities said Nikolai cannot be buried in a Jewish cemetery. The reason for that, because her mother was not a Jew at the time of his birth. Only his father was a Jew. So he was not a proper Jew. He cannot be buried in a Jewish cemetery in Israel. So what happened at the end of the day? His family from Russia came to Israel, took his body back to Moscow to be buried there. The paradox that we are facing here, he was good enough to make an aliyah, to migrate to Israel. He was good enough to serve in the army, so he was trusted with a gun to protect the Jewish state against his enemies. And he was good enough to die for the country that he loved so much, but he was not good enough to be buried in Israel. The three very brief narratives that I'm just telling you are not exceptional stories. They are, in fact, everyday life stories of billions of people. About 1/3 of the world population today live under such legal systems known as personal status systems. What is a personal status system? In personal status systems, most of the time, there is not a single territorial uniform law that all citizens are subject to. Instead, you have a legal system under which everybody is subject to their own communal institutions, particularly in regard to personal status matters such as marriage, divorce, inheritance, paternity, etc. For example, under such a legal system, a Muslim will be subject to Islamic Sharia courts or Sharia law, Jews to rabbinical courts, and Christians to ecclesiastical courts, and so forth. Historically, such legal systems, personal status systems, had been employed by imperial regimes to categorize or compartmentalize their colonial subjects into tribal, confessional, sectarian groupings in order to deny certain groups terms of equal membership in the political community, deny goods and services to certain groups. So from a historical point of view, it's understandable why a colonial regime would have used such a system because they want to divide and rule. But the paradox that we have, or puzzle that we are facing here, why would many modern nation states continue to use such legal systems and compartmentalize their citizens, despite the fact that they're constitutionally under obligation not to discriminate on the basis of gender, sex, religion, or ethnicity? So that is the number one paradox or puzzle that I'll be looking into in this study. Why so many countries continue to have personal status systems, particularly looking at the case of Israel, Egypt, and India tonight. The second question that leads my research is how these religious legal systems, how personal status systems impact the fundamental rights of men and women in particular. And thirdly, how people cope with or respond to violations or limitations of their rights under religious legal systems. What tactics and strategies they resort to employ in order to navigate through the maze of personal status laws. So again, these three questions will lead the discussion tonight. And let me just briefly tell you what kind of data set that I'll be using tonight. Again, this study is based upon my ongoing manuscript or book project. I collected data through my field research in Israel, Egypt, India, as well as UK, archival research. I spent long hours sitting in the religious courts. I interviewed, and most recently I was in Sierra Leone. That is the fourth country that I have added on top of my 3 set countries to look at the very similar systems in sub-Saharan Africa. I interviewed about 200 people, including mostly judges, lawyers, religious leaders, and human and women's rights activists from about 20 different communities that include Jews, Copts, Muslims, Sikhs, Hindus, etc. So 20 communities. So there's a lot of ethnographic data I'm hoping to present tonight as well. The structure of the presentation as follows. First, in the first part, I will tell you about the political foundations of personal status systems. In the second part, I'll tell you about the implications of those legal systems on fundamental rights and liberties. In the third part, I'll tell you, summarize how people respond to those challenges, what kind of responses they give, what tactics they use to advance their own rights from within. And in the fourth, very last part, I'll summarize the findings of the research and also tell you if there are any best practices or if there are any best ways to integrate the so-called universal or international human rights or women's rights standards into customary and religious legal systems. As I just said, personal status systems had been historically used by imperial regimes. Again, the main purpose of using those systems was to compartmentalize people into tribal religious groups, to know who is a Muslim, who is a Jew, who is a Sunni, etc. And again, they were used to deny the terms of equal membership in the political community, to deny certain goods and services to certain groups. So at the time of independence, more or less all post-colonial nations had faced the very same dilemma. What to do with these polycentric plural systems? They had a couple options. Number one, again, since you have Muslim courts, Jewish courts, Christian courts, what you could do institutional unification, meaning that you can abolish all different courts and unite them under one single overarching body. So getting rid of all Muslim Christian courts, having one secular civil court instead. Another option was normative unification, for example. Basically, you will abolish all different bodies of laws, Muslim law, Jewish law, Christian law, and you will replace them with a secular code, a civil code that will be applicable to every citizen, regardless of their religious or ethnic backgrounds. This is, for example, what Egypt did in 1955. This is what India have tried to do in 1950. And my own country, Turkey, have done both. We had a crazy leader with the name of Atatürk. Overnight, he abolished all religious courts, abolished religious law, and he brought the civil code from Switzerland in German, and he asked for translation of that code. And he said to Turks, from now on, this is your family code. And this is also something you could do. So some nations have done both, some done neither. So what determined the response the state has given to these multiple jurisdictions, religious law, in the first place? That is, in the first hand, you have ideology. Political orientation plays a very instrumental, pivotal role in determining the response of the state. On the other, you have the configurations in state-society relations. So different regime choices, differing configurations of state-society relations in every country has led to emergence of varying forms of personal status systems across the post-colonial world. What I have done in my research, I have tried to summarize them and put them into three broad categories. All personal status systems which you can find from Malaysia to Morocco, if you like. As I said, about 1/3 of the world population is ruled by those legal systems, can be divided into three ideal typical models. One is the confessional system, like the personal status system I'll talk about in Israel. The second is Unitarian system, like the one we have in India. And the third one is instrumentalist model that we currently have in Egypt. I'll tell you what each model stands for in a moment as I explain the countries which stand for each category. Let me start with Israel very briefly. By the time Israel was an independent state in 1948, Israeli leaders found in place a personal status system known as millet. That was the Ottoman millet system, personal status system. They inherited this legal system with 11 communities, under which Muslims, Jews, and different denominations of Christianity had their own court and applied their own laws. However, since independence, Israel never attempted to carry out an institutional unification in the sense that trying to unite its courts, never tried to do normative unification, for example, as India did, trying to replace them with secular laws. Instead, Israel utilized the existing millet system and to a large extent preserved the millet system which still continues to exist today. Why that was the case? Israel was, ideologically speaking, was an exclusionary, theocratically oriented country. What do I mean by that? An exclusionary state is a state which discourages intermingling among its citizens, which tries to keep the citizens, different communities, detached from one another. The purpose of the state is not to establish a civic composite nationhood, but to keep communities, ethno-linguistic communities or sectarian communities, detached from one another. So for that purpose, Israel utilized the millet system that it inherited from the Ottomans for two purposes: to homogenize Israeli Jewish population or identity, and to segregate or distinguish non-Jewish identities. In 1949, Israeli government said, we will never introduce a civil marriage bill, which means there will never be interfaith marriages in Israel. Because civil marriage stands for interfaith. A Muslim being able to marry a non-Muslim, a Jew being able to marry a Christian, etc. And most important legislation passed by the Knesset, Israeli parliament, was in 1953. That is the Rabbinical Court Jurisdiction Act. Let me here tell you very briefly about the rules of marriage under Israeli law. Again, there is not a single civil law in Israel. Marriage depends, or marriage is subject to religious law. When you go to a supermarket in Israel to buy a can of soda, it will say it's kosher. It will write on the bottle, it will say, or can, it was kosher, which means that state or the local authority, which makes sure that the soda that you're about to drink is guaranteed by the state, is permissible, you drink it. When you drink it, you are not going to commit a sin. The state guarantees that. By 1953 law, the state did the very same thing for people who are about to go out to marry. So once you go to marriage market, you're looking for a spouse, the state guarantees with 1953 law that the spouse that you're going to find, the marriage that you're going to do is going to be kosher. and the offspring of that marriage will be kosher as well. But with the law, the state said, in the state of Israel, all Jewish residents, citizens and non-citizens, are subject to one law, that is the Orthodox halakha, applied by the state-run rabbinical courts. In fact, before 1948, some non-conformist Jewish communities, like Karaim, like Samaritans, they had their own jurisdictions. Under the British, under the Ottoman, they were allowed to have their own tribunals for their own community members. But what 1953 law did, it abolished those jurisdictions, and it recognized only one single jurisdiction, state-run Orthodox jurisdiction, for all Jews in the country. So what state was trying to do, in fact, if you look at the debates around the law in the Knesset in 1953, they said one single purpose of the law is to make sure that Jews from Poland can marry Jews from Yemen. Because after 2,000 years of exile, all the Jews are coming from four corners of the world, coming to the biblical kingdom. So what the sole purpose of the founding fathers of Israel was to homogenize those populations, melt them in the same pot, and create one Sabra Jewish identity. So legal unification, all Jews were united under one single Jewish law. But homogenization of Jewish identity logically necessitated distinguishing or segregating non-Jewish identities. So what Israel did, as I said, in 1948, Israel had 11 communities inherited from the Ottomans. Do you know how many communities exist today in Israel? 14. So which means that number soared from 11 to 14 under Israeli rule. And most instructive example is the Druze community. Ben Gurion is on record saying one time, we have to foster among the Druze an awareness that they are a separate community vis-a-vis the Muslims. For this, we have to establish the regime which existed in the days of the Turks, broad autonomy for the Druze community. Under the Ottomans, under the British, the Druze population in Israel, Palestine, did not have legal autonomy. They did not have their own community. They didn't have their own courts. But what Israel did in 1947, the Israeli government recognized the Druze as a separate religious community, and in 1962, they set up independent courts for Druze people. And they also further encourage and maintain those divisions within the Arab population, those religious differences. Again, that was a part of the divide and rule policy of the Israeli regime in order to establish a control of domination among Arabic-speaking population. And most importantly, what this legal regime did, I think we have a battery problem here. So what this law did, what the recognition of Druze community did, basically Arabic-speaking populations were kept in a way fragmented. They were not able to intermarry. A Druze in Israel cannot marry a Muslim Palestinian cannot marry, for example, a Christian Palestinian. So that Arabic-speaking populations were kept fragmented while Jewish populations were kept homogenized and united.
Sorry, everyone.
Are we done? Thank you. Okay. That's okay. I'm not going to hibernate, so it's only computer is going to hibernate. Let me move to India, what India did on the other hand. Unlike Israel, India was a secular socialist democratic republic. Again, India is a socialist secular democratic republic. And again, unlike Israel, India wanted to create a composite nationhood. They wanted to create a civic national identity. They wanted all Muslims, Sikhs, Hindus to be melted in the same pot and come up with a new single identity that will be Indian identity. They didn't want the new citizens of India to refer to themselves as a Muslim or Christian or Sikh, but as an Indian. And the founding fathers, again, particularly Nehru, considered the persistence of personal laws or personal status systems as detrimental to the national identity and inhibiting the social progress of the republic. For that matter, when India was founded, in the 1950 Constitution, it said, Article 44, India should have a secular civil code, uniform civil code, that will replace these diverse bodies of law, Hindu, Muslim, Parsi, Christian law, etc. There will be one law, secular law, and that will be applicable to all citizens throughout the territory of India. So the idea is that one nation under one law. However, that dream had never been fulfilled. And that was mostly because of Muslim opposition to the idea of abolishing Islamic law and replacing it with the secular law. What India instead has done, by the way, since they were not able to enact a uniform civil code, they at least unified the law for Hindus. So in 1955-56, they, to some degree, secularized, standardized the Hindu law for Hindus, Sikhs, Jains, and Buddhists. And by the way, they were all defined as Hindus by the law, whether they like it or not. And they were united under one single law. That's the Hindu Code Bill of Reforms of 55-56. However, the country has so far failed to enact a civil code that will be applicable to everyone. One purpose, particularly if you look at the parliament discussions that took place in 1947 to 1950 in India, they said in a secular republic, people should be able to marry whether they are coming from a Muslim background, whether they are coming from a Jewish background, Christian background, or Hindu background. So regardless of the religious distinction, citizens should be able to intermarry so that it will create a unified Indian nationhood. Are we good here? Good. Thank you. Since India was not able to enact that uniform civil code, in its place, they passed 1954 Special Marriage Act. 1954 Special Marriage Act, which says under which law interfaith marriages is permissible, possible. So as a secular republic, as a socialist republic, in the absence of a uniform civil code, at least India was providing an option, alternative to its citizens. Unlike Israel, Israel has never more or less attempted to do so. All right, so having talked about the political foundations, what kind of impact these legal systems, religious or legal systems have on the fundamental rights and liberties? Personal status systems, this is what it stands for. Personal status systems, they institutionalize discriminatory patriarchal structures by giving them formal recognition and state backing. And particularly, application of these religious laws, so-called Muslim law, Jewish law, Christian law, etc., if they're applied to people without their explicit consent, it is detrimental to their fundamental rights and liberties. And this is more true, especially in places where there are no secular alternatives given to citizens, like in Egypt or Israel. Most vulnerable groups under the personal status systems are, on the top of the list, you have women, children, religious dissidents, you have people who do not belong to recognized communities, etc. Let me just give you a couple examples to common violations that you come across under personal status systems in these three countries. Some of them, and most important, they are related to marriage. For example, in personal status systems, a lot of people are denied the right to marry. And this is best known, particularly in the context of Israel, and the very well infamous question or issue of who is a Jew question, right? So, according to halakha, which is interpreted and applied by the Israeli state, before the marriage, every single person has to be vetted by the religious authorities to decide or determine the Jewishness of that person. If you are not a proper Jew by halakhic criteria, you might be denied the right to marry within Israel. As I just gave the example of Nikolai, right? According to halakha, basically your mother has to be a Jew at the time of your birth to be considered a Jew, or you have to be converted into Judaism by a recognized rabbinical authority. That's most of the time an Orthodox one, in particular in Israel. The number is very much contested, but at least about 400,000 people in Israel are denied the right to marry within Israel. And the problem has become much more acute, particularly after the arrival of more than 800,000 Russian Jews in 1989, after 1989 to Israel. And about 20% of those people are considered non-Jews in halakhic criteria. Imagine, the number is about 400,000 to 500,000. This is about 8% of the Israeli Jewish population. Imagine we tell about 24 million people in this country, yes, you are an American citizen, but you are disqualified from marriage, so that you can understand how big the problem is and how divisive the problem is in Israel. Of course, you have the problem of bigamy or polygyny. Particularly, this is true under Islamic law. In Egypt, for example, in India, a man can have up to 4 wives. And in Israel and Egypt, also the problem is with interfaith or interreligious marriages. In Israel, for example, within Israel, there is no way to conduct an interreligious marriage. This is also to some degree true in Egypt. For example, a Muslim woman cannot marry a non-Muslim man. This is a serious prohibition in terms of fundamental rights. And you also have some divorce-related complications or detrimental issues. For example, under the Indian Muslim law, you have the issue of triple talaq. Talaq meaning that divorce you. So under the Islamic law, again, how it's interpreted by the Indian authorities, a man has a right to unilateral extrajudicial divorce. Without going to court, a man can say, talaq, 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 triple talaq. At one sitting, about 5-10 seconds, you can divorce your wife. In fact, under the law, you can even do that through text messaging. If you have a free text messaging, you can do that. You can do it through Skyping. You can do it through phone. So those are the very serious issues under Islamic law as interpreted in India. You also have get aguna problem. Under the halakha as interpreted by the Israeli state and Israeli rabbinical courts, in order for a woman to be considered divorced, a man has to write a piece of paper known as get. So once the get is issued by the husband to the wife, she's back to the market. She is free. So she can marry anyone she wants. But until the paper is willingly issued by the husband, the woman is not released from the bond of marriage. If she conceives a child from another man while she is being still denied a get by her husband, that child will be a mamzer. A mamzer is a very serious implication. You will be denied a right to marry other Jews for 10 generations. And the state of Israel, the state of, Ministry of Interior Affairs, keeps a list of mamzerim in the country. Last time when I checked the list, there were about 94 registered bastards in Israel. And the Prime Minister Netanyahu was not on the list. So, another issue is with apostasy. That example comes from Egypt. Under the Egyptian criminal law, or under the Egyptian positive law, apostasy or renunciation of Islam is not a crime. Under classical Islamic law, apostasy is a crime, punishable either by death or banishment, depending upon who interprets the law. But according to Egyptian positive law, it's not a crime and it cannot be punished by the state. However, there is a backdoor approach. There is a loophole in the Egyptian system. If you bring apostasy charges to the court in connection with family law issues, in connection with matrimonial issues, you can have someone declared an apostate by the courts. Let me give you an example how it works. That happened in 1993 to Professor Abu Zaid, for example. So there is an Islamic principle known as Hizbah. According to Hizbah, every Muslim has a right or duty to fight against the evil or to protect the rights of God. So what you can say, this person's writing amounts to heresy. So since her writing, for example, that also happened against Nawal al-Saadawi in recent years, this person's writing amounts to heresy, so she has become an apostate. So you go to court and say, since she has become an apostate, she has to be divorced from her husband. Because again, under the Islamic apostasy rules, once you renounce Islam, your marriage becomes void or invalid. So if you make that connection with the matrimonial matters, the court has to entertain the question whether that person's work amounts to heresy in the first place. And in fact, in 1993, in the Abu Zaid case, the Court of Cassation in Egypt said, yes, Professor Zaid's writings amount to heresy. So what you see here, even though apostasy is not a crime under the Egyptian law, there's a backdoor to do that if you connect it with matrimonial matters. And what happened to Abu Zaid? Where is he now? He lives in a self-exiled Netherlands. He died?
Yes, he's died.
Oh, sorry about that. Sorry about that. That's my fault.
But he did live.
Yeah, he did live, exactly. So basically the issue here is because you are forcefully separated from your spouse, and once the court determines or decides that you are an apostate, it's a sort of an order waiting for an executioner, for example. A fundamentalist group could assassinate you anytime. That's the ugly face of this issue in Egypt. There are also forced conversions, as I mentioned in the case of Halasitki or Resham from India, for example. What I call them forced because most of the time, it's particularly in the context of women, they are forced to find a way to get out of a deadlock marriages. So in a way, they are forced to leave their own faith and adopt another religion. Or sometimes conversions are carried out of lust. For example, you're a Hindu man, you see your neighbor Muhammad having 4 wives, and you say, why can't I have 4 wives? So what do? You just recite Shahada in about a couple of seconds, you become a Muslim, and then get 4 wives. So again, sometimes conversions are done out of lust or convenience rather than conviction. And perhaps another very important problem, as I said, in Israel, there are 14 communities. All those communities are particularly and directly recognized by the state and granted a legal autonomy. What if you belong to the 15th community? What if you belong to a community which is not recognized? What if you're in Baha'i in Egypt? Or what if you're a Protestant in Israel? You don't exist. In the eyes of the state, you don't exist. Basically, you cannot marry, you cannot divorce, you cannot do anything. Your civil rights in that regard, family rights, do not exist within that legal system. All right, so what individuals do? Do they just silently sit on the sidelines and accept the violations or limitations on the religious law? No, and particularly women do not do that. There are 3 major strategies of resistance under personal status systems that I have been able to identify. Number 1 is forum shopping. Forum shopping, in very simple terms, is the litigants or individuals traveling from one jurisdiction to another jurisdiction in pursuit of legal gains. As I said, you can do deceitful conversions, like Halasitki did. You just change the denomination so that you can get the legal result that you want. Or like a Christian man in Egypt, you just embrace Islam so that you can get multiple wives. Or like the Cyprus marriages. If you're a person who is unable to marry within Israel, what you do, you go to Cyprus, marry civilly in Cyprus, and come back to Israel and register your marriage as a marriage under the Population Registry Act. So that's a way to, in a way, bypass the limitations of religious law. Another one is self-ruling communities. This is another tendency that I've been able to identify. Some particularly very secular organizations, their desperation has grown to some point that they, at some point, stop using the mainstream family law institutions. They say, we're not going to marry under the existing law. We're not going to seek divorce under the existing law. So what we are going to do, because the state is unresponsive, because the state is oblivious, religious authorities are oblivious to our demands for change. So what we are going to do, we are going to set up our own institutions. The best example that I've been able to find in Israel, in these 3 countries is from Israel. That is the organization known as the New Family Organization, a Tel Aviv-based organization. What they do, for example, this is a secular organization that's very much against the regulation of marriage or matrimonial matters by the state. They set up their own, for example, jurisdiction. In a sense, they've been able to solemnize marriages among some secular Jews who do not want to be subject to rabbinical law. And they've been also able to grant divorces or facilitate divorces among their own members. The third means of resistance is hermeneutic communities, which I would like to particularly focus on tonight. What are the hermeneutic communities that I'm talking about here? These are the groups, and most of them are established by women's groups in these three countries. They try to reinterpret the so-called sacred text, narratives, religious tradition, through feminist and liberal lenses in order to locate and advance women's and human rights. So they reinterpret the existing tradition. At the same time, what they do, they translate the global discourse of women's rights or human rights into local vernacular. They graft those egalitarian ideals and principles onto local culture and institutions. In the case of hermeneutic communities, the demand for change is not imposed from outside, but the demand comes from within the community. And most of the time, what you see, or I have been able to observe, you see cross-communal and transnational coalitions. For example, you would see Muslim women and Jewish women working together. You would find Hindu women and Muslim women working together in order to advance their own rights under the patriarchal personal status systems of those respective societies. Let me give you a couple of examples to hermeneutic communities. One of them is coming from Egypt, and this is, I would say, one of the most successful examples to date. Egyptian women's organizations from 1985 until 2000, they fought a very long battle in order to advance their rights. They were mobilized to advance their rights to marriage, rights to divorce under Muslim personal laws. And what they did, they worked like archaeologists. They were excavating very hard to find a ground on which they can ask the parliament or the president to give them a new rights. And finally, the groundbreaking excavation was, they found an old hadith in which a woman comes to Prophet Muhammad. She says, if I may paraphrase, I hate my husband. Ya Muhammad, what can I do? What is the solution? And Muhammad replies back. He says, what did you receive as a dowry? She says, I got an orchard. And then Muhammad replies back, and he says, all right, then give the orchard back to your husband, consider yourself divorced. And the authenticity of this hadith had not been contested. It's a true, authentic hadith. And based upon that fact, women's organizations built their entire struggle from 1985 until 2000. And finally, Egyptian parliament, law number 1 of 2000, finally gave women a right to divorce known as khula, literally, which means extraction. So again, that was one of the most successful hermeneutic activities, and that resulted in legislative change in Egyptian law. Another example is coming from particular Jewish Orthodox communities and women's organizations in Israel. As I try to explain, one of the major problems for Jewish women is the issue of aguna. There are about 8,000 to 10,000 aguna or mesravet get in Israel currently, meaning that of women who are denied a divorce or get by their husbands, 8 to 10,000 women. And there is an international coalition known as ICAR, International Coalition for Aguna Rights, for example. Women from Reform communities, conservative communities, Orthodox communities, they come together, establish consortiums to advance their rights. One thing they came up with in recent years is halakhic prenuptials. Basically, as they sign the ketubah, they're adding a prenuptial on top of ketubah so that women could at least get the divorce, get paper from the husband if certain conditions are met. Another one is women had been trying since 1990s to increase the women's representation in rabbinical courts. Rabbinical courts are unfortunately very male-centric, male-dominated institutions. According to halakha, as interpreted by the Israeli state, women cannot become dayanim, or rabbinical court judges. But there are two organizations known as Kolech and Mavoi Satum in Israel. They had been very recently also working on establishment of parallel rabbinical courts in which there will be female dayanim, there will be female judges. And also women were able to, since women cannot become a dayan, in the meantime women said, all right, if we cannot go into the court, what we can do, we can influence the process through which dayanim are appointed. And women were able to put a member, female member, on the dayan nomination board in recent years as well. Also, among the Muslim women's organization in Israel, there are certain trends which are very similar to Orthodox trends or Jewish trends. There is an organization based in Nazareth known as Working Group for Equality in Personal Status. This organization in recent years is working for, particularly in the last 2 years, they had been pushing for appointment of female qadis, female Muslim judges to Israeli Sharia courts. In March 2009, Palestinian Authority in the West Bank did something historical. For the first time ever, they appointed 2 female qadis to Sharia courts. And that was really the inspiration for the Israeli-Palestinian Muslim women. They said, since our sisters in West Bank can have it, we want to have the very same rights here. And they started mobilizing and pushing the Israeli state for appointment of female qadis. But the problem is, do you know who rejects that idea most, objects that idea most? Not the Muslim Jewish, or not the Muslim religious authorities, but it's the Jewish authorities in the first place. Because they are afraid and they are very fearful of the fact that if female qadis are appointed to Sharia courts, then that will open the door for appointment of female dayanim as well. So what you see as women, Muslim women and Jewish women, Christian women, they establish coalitions to progress their own rights within this patriarchal system. You see conservative Muslims like conservative Orthodox Jews, they also build coalitions to stop women from progressing. There is another example which is Nisa Wafak, basically which is inspired by the ideals of Marnisi and Benani, the Moroccan scholars of Islamic feminism. And they are very much inspired by Kolek, an Orthodox Jewish organization. In fact, the person who established Nisa Wafak was trained in Bar-Ilan University, an Orthodox institution in Israel. She's a female Muslim lawyer, and she was very much inspired by the example of Kolek. And one of the very last examples is coming from India. Again, as I said, the major problem for Indian women is triple talaq, right? Just pronouncing talaq at one single sitting. And the issue then, post-nuptial maintenance is also another issue under the law. What Muslim women's organizations are doing in India, they establish All India Muslim Women Personal Law Board. This is an institution, in recent years, in 2004, issued a nikahnama, a marriage contract. According to this marriage contract issued by women, triple talaq is prohibited via text messaging, email, or video conferencing. So you cannot divorce your wife with text or Skyping anymore if you marry under this new contract. It also recognizes women's right to delegated divorce under Islamic law, and also women's right to no-fault divorce to khul. Again, I don't want to read too much into this new development, because if you consider the huge size of India and the Muslim community, this is a very tiny initiative in the city of Lucknow in India. For example, last time when I checked, only about 200 couples were married under this new contract, but at least a very encouraging development. And most recently, this new organization also established a women's Sharia court, known as Mahila Adalat, in which women apply Sharia, Islamic law, from a woman's perspective, and you will also have female qadis applying Islamic law. All right, so moving to the last part of the discussion. What is the best way, if there is any, to protect women's rights or international human rights under religious law, particularly personal status systems? As I have tried to just show, religion-based personal status systems are political constructions. They are not sacred laws, or there is nothing sacred about them. They are secular, mundane constructions, political constructions. Number two, as we speak of Jewish law, Muslim law, Hindu law, so forth, We talk about masculine legalities built through androcentric reading of the text, tradition, and narratives. They heavily discriminate against women's rights. And another thing that I've been able to observe in these three countries, although they're indispensable, top-down secular initiatives, top-down secular attempts to reform have unfortunately failed, and they often backfired to advance the human rights or women's rights. And this is especially true in the minority settings. The issue here is, if you're a Muslim woman in Israel, you cannot expect much from the Knesset. You cannot expect much from the Jewish round courts. So change has to come from within. The issue again here, for a Muslim minority, everything is about identity. Everything is about the survival of the community. You are not allowed to talk about issues of marriage. If you raise your voice within the community and start talking about issues of marriage, divorce, etc., they will say, no, we can't do it. We first have to win the war against the Zionist entity. That's the same in India. If you're a Muslim woman in India, the patriarchal authorities within the community would say, no, we cannot do it, because it's about identity. For example, Indian parliament cannot do much. Indian courts cannot do much. They will be seen as a hostile attempt to take over the community or attempt to destroy the identity of the community. So in that regard, hermeneutic communities has a huge role and potential to play, particularly in Muslim minority settings. In the process, what hermeneutic communities do, they challenge the androcentric legalities. They challenge the political constructions. They challenge the established boundaries of ethnicity, religion, subjectivity, gender. They redefine everything. Another issue, however, that we have to highlight here, the change that will come through hermeneutic communities will be gradual and limited change. Again, we have to recognize it will take time. We may not be happy, perhaps if you talk from the perspective of international community, UN, for example. We may not be happy with the amount of the change or the pace of the reform, but it's very likely that in the long term, hermeneutic approach is much more productive than top-down secular approaches to reform. Hermeneutic approach is also an interim strategy. You cannot solely rely upon hermeneutic communities or hermeneutic approach to uplift, so, for example, women in Muslim community, in Jewish community, in Hindu community, etc. There is a glass ceiling. What I mean by that, there is a limit to what you can achieve through hermeneutic approach. You cannot simply wash away the fundamental inequalities that are inherent in certain traditions through hermeneutic approach. But there is a serious potential. Once you recognize those limitations, you can manipulate the hermeneutic approach to uplift the woman in personal status systems. Lastly, what I want to say, my study, my work, is not necessarily arguing for cultural relativism. I do acknowledge the tension between universal human rights and cultural relativism. However, what I consider, humbly speaking, if you like, is a bottomless pit that I would like to avoid. So I don't want to get into those issues or discussions of universal rights versus cultural rights. There should be a certain amount of rights which we can consider as universal and common to all human societies, whether Muslim, Jew, or Christian, etc. So if we once accept those principles, then we could work towards vernacularization of those principles or translation of those principles into certain communities. Yes, the pace is very important, we recognize that, but at the same time, we should let the communities and societies to pick what is best for them, and in the process, adopt those so-called universal rights to their own cultures. Thank you very much.
Thank you so much,
Yes.
Yüksel, and I hope you will take some questions.
Yes, why not? Yes. Yes.
I'm coming to you with the lawyer's mind. My name is Shibni Mama.
Yes.
At the law school. I think it's highly entertaining and extremely thought-provoking. But if I may offer a little bit of criticism that I hope you take to sharpen the manuscript.
Yes.
It seems to me that there is confusion in the approach that you're giving to two legal orders that operate with logics that are not quite the same. There is one legal order that operates within the community. In other words, when Muslim women are trying to enhance their status to advance gender equality, then the methods for this are very different from that other legal order with which you started, and that is the equality between people belonging to two faiths in those sorts of pluralistic legal societies. It doesn't at all operate under the same logic.
Yes.
So what I heard in the talk is what I sensed could be a sharpened difference between both legal orders and the logics that they compel in terms of reform, if that is the reform that we're seeking. The first one, that is the equality of genders within a given community that is defined religiously or on the basis of a sect, is one where it seems to me there has been far more progress and in far more clear ways legally over the past 100 years for the equality of genders, particularly for Muslim women. And to that extent, this argument of the top-down and bottom-up, I'm afraid, does not, I think, correspond to actually a very serious work of legislative reforms and jurisprudential work at the level of the courts that has established what I think, or what I wrote about, as something that is a clear line without which you don't understand a single legislative reform in the past 100 years in the Middle East if you don't pay attention to a combined elite popular pressure for gender equality. The other legal order is more complicated. It seems to me that it would benefit a lot in your very enticing analysis if you made the distinction between what happens on the personal status level and what happens on the personal status level and what is detrimental in terms of the citizenship equality in the states where discrimination operates, as in Israel or Lebanon or most of the Middle East on the basis of sect. It's a very different logic. I don't think that you can put them together easily enough. And one example of the methods that people go for are the civil marriages. People are rarely deterred by their laws from intermarrying in our countries. Either they go for Cyprus or France, or there are ways even inside where you could, in Lebanon, contract, or even in Israel, you can contract if you're a Jewish woman, you can contract in a Muslim, before a Muslim sheikh. It will be recognized. It creates all kinds of problems. It doesn't happen because there is resistance, but it's not the law that is resistant. It's the community that tends to be resistant, and the sheikh who's not very happy of having this sort. Well, sometimes he's happy, especially if it's a Muslim woman, a Jewish woman who comes to marry a Muslim man. The reverse is probably not true. So what I'm saying is that there is different legal order and legal logic operating on interfaith that's not quite the same as one that operates within the community.
Very good point. Can I answer the question? Okay. I think that's a very valid point. In fact, this is one of the things that I'm, unfortunately, because of time limitations, I had not been able to, touch upon that issue. As you highly rightly indicated, there are different levels of equality that we talk about. One is intra-group, basically, for example, equality between men and women within the Muslim community. But also you talk about gender equality across the groups. So one of the most important implications of having such legal systems is that sometimes you give certain rights to women of one community and you deny the same rights to women of another community. One thing though, however, Lebanon is a fantastic example, but I've never done any serious research on Lebanon, so I cannot really talk about that. But in the context of Israel, for example, in 1951, the Israeli parliament passed the Women's Equal Rights Law. According to Women's Equal Rights Law, divorcing wife against his own will is a crime punishable with incarceration. So you cannot talaq in Israel, according to positive law of Israel. So that law was passed basically as an indirect intervention in the Islamic law. And Israel, being a non-Muslim country, had never consider itself having the necessary legitimacy to directly legislate Islamic law. So they bypass that through indirect penal regulation. But the problem here, as I interviewed the Qadis in Israel, currently there are 11 Qadis in Israel, and I interviewed about 4 or 5 of them. What they told me that they are not bound. This is the 3rd generation of Qadis since the independence of State of Israel since 1948. So 3rd generation of Qadis are more inclined to assert their own independence from the State of Israel, even though they are salaried and appointed by the State of Israel, even though they are sitting in front of an Israel flag, they are sitting in front of a menorah, etc. But they like to play that game. From time to time, in their internal writings, for example, correspondence, they will refer to courts as the Sharia courts of Palestine, not Israel at all. But in reality, again, as the Qadis told me, they basically don't like to apply the Islamic law. They don't like to apply the secular laws of Israel if they are violating the Islamic rights. So they still continue to allow men to talaq their wife. So I understand those intercommunal and across communities separation or equality issue, but at the same time as I try to indicate my own research, whenever a state intervenes in order to impose that kind of intercommunal equality, that's always registered by more or less patriarchal elements within the community. But again, I recognize that problem. Yes?
Yeah, I'm not quite sure. In the beginning, you brought together several different states. I mean, you had Israel and you mentioned India, and whether you paid enough attention to the context of these states. In other words, it seems to me in Israel has a problem. It wants not only to be recognized as Israel, but it wants to be recognized as a Jewish state.
Yes.
So that means the law giving is going to favor the Jewish state.
Yes.
It seems to me in India, where you want to establish a national state among diverse religious communities, you have a completely different underlying intention. And that's what's involved in Europe. So that actually, when you look at these different circumstances, you have to say, what's the historical configuration of statehood?
Yes.
That's either trying to establish statehood as religious in some way, or that's trying to establish statehood in a way that includes multiple religious denominations.
Yes.
And then in each situation, that would have a completely different effect. And in both states, could you not say that law has a hermeneutical intent? In other words, the reason why you want to have a law which is religious is you want it to form a particular mentality.
Exactly.
And the reason why you want to have a law that transcends religious sectarian groups is that you want it to have a hermeneutical intent. So to put law just as a top-down strategy, and not to say that law itself has a formative or a qualitative or hermeneutical intent, is also important for the analysis.
Yes, yeah, it's very true. In fact, it's one of the things that I'm trying to do in the research. Those laws have been manipulated. I don't use the hermeneutic, but I use the term they've been manipulated by the political elite.
But that's a negative. When you use the word manipulate, you're automatically casting law.
Or let's say utilize. In the Israeli context, I said they utilized the law to achieve the two goals. Again, they wanted to create a Jewish state, Jewish majority. And again, for example, I think I have it here. Ben Gurion. If I may just share this quotation from Ben Gurion with you for a second. And he talks about 1953 law, rabbinical court jurisdiction law. He says, I was for the law for a simple reason. After World War II, immigration came primarily from Asia and Africa. Of these Jews who came in this great wave of immigration, I knew that one thing was holy to them, family purity. Again, what the main purpose of the 53 law, or establishing the mandatory jurisdiction of rabbinical courts over all Jews, is to make sure that the family purity will not be violated for Jewish people. So without questioning, in fact, they very often in the Knesset during the discussions, they very often use the terminology that we don't want the house of Israel to be divided into two. So you don't want to create two nations, Jewish nations, marriageable, unmarriageable Jews. In order to avoid that problem, they establish a mandatory jurisdiction. In the Indian case, however, again, what you see, Ben-Gurion was a socialist. Ben-Gurion was an enormous agnostic. He used to make fun of Jews who didn't eat pork. He used to say he'd never been to a synagogue in the state of Israel. He married his wife in 1917 in the US in a civil ceremony. His son married a British nurse, non-Jew. He didn't care about religion, but he understood the instrumental value of Jews for those exiles coming back to Israel. So he said, since we're all Jews, we cannot get rid of religious law. For Nehru, however, he was a very socialist, very secular-oriented person, and he said we have to get rid of religious law. In fact, if I may just offer you a speculation, if you like, counterfactual, if Gandhi had not been assassinated in 1948, the picture that we see in India today would have been very different, because Gandhi was much more in favor of using religion in the public life as a symbol of unifying Hindu majority. There were also other factions and groups within the Indian parliament, like RSS. They also wanted to use religion, the Hindu religion in this sense. But again, at today, the secular forces were much more predominant, so they rule today. I agree with that. So, perhaps, again, I was not able to convey that during this short time, but I spent quite a lot of time going into those particular formation of the state and writing of the Constitution, how they conceive those ideas. Thank you for the great question. Can I take any question? Yes?
My name is Werner. I'm a European lawyer and a student of theology here at the Divinity School. I would like to make a small remark on your speech about Israel, specifically about Jewish identity, Jewish religious identity. I think that you omitted a crucial nuance there, because there is a huge difference between the definition of who is a Jew as made by the state, which is a very liberal and very open-minded definition. A lot of people can immigrate and make aliyah without being halachically Jewish, and the definition that is made by orthodox rabbinical courts defining who can marry. And that is a huge, so if we speak about who can immigrate to Israel, if we speak about the interpretation of Jewish identity by the state, we have to realize that they are very open-minded and not very discriminatory at all.
I think that's a very good point. I think I didn't have time again, but the issue of Nikolai Rappaport, if I may just go back to this fallen hero, Israeli hero. There is a law written from 1970. That law was also, again, amended in 1970. According to law, it says, it's a very liberal, if you like, definition. Again, you have to understand demographic concerns of Israel. It's a very tiny state. It's trying to bring as many Jews as possible to the land of Israel. Any person who has at least a Jewish grandparent can make aliyah or migrate to Israel. But according to halakha, you have to have at least, your mother has to be Jew. So there's a discrepancy, a normative discrepancy between the secular law and the
Yes, that's true. And I
religious law.
So the brevity of your speech, it also goes for conversions.
Yes.
Within Israel, only Orthodox conversions are recognized. But if you would convert here in Boston in some kind of very reform or very liberal conversion, that would be recognized by the state, and that would give you the possibility to make aliyah.
Yes, it may, though there are some issues with that. It's from time to time come to the Supreme Court of Israel. Not all Orthodox conversions in the US are automatically recognized in Israel. Yes.
A very short, brief comment with your permission.
Yes, please.
As I was involved in some of the organizations that you mentioned before, Connect, etc. As far as Israel is concerned, I believe that the target should be to change the law. I mean, to separate religions from the state, because and at the end this what will happen, because there is too many programs. There are a huge percentage of the population that can't marry, as you said. So I believe that the end the solution would be grand solution by separating state and religion. And in my opinion, as a religious person, a halachic and orthodox person, this is the ultimate solution for religion. I mean, when this will happen, you will find how relaxed the rabbinic court will be.
Yeah.
But what's important to understand is that, in fact, in Israel, the civil law was able to a substitute to marriage at all. Because in Israel, so you don't have to marry in Israel to get all the benefits of marriages. So what happened is that, in fact, people doesn't have to marry. There is a law of Yedu'a B'Tzibur, I mean, couple who are known as spouses, and this gives them all the benefits, etc. Paradoxically, it made Israel one of the most liberal countries, for example, in relation to same-sex marriage, because you don't have to be married at all to get the rights. So gay couples in Israel have the same rights as marriage, and etc. So there is it's a very complicated and interesting issue. At the end of the day, in practical terms, it happened that the most, officially strained law happened to be a very liberal one on practical matters.
I mean, it's a very good point, but it's not necessarily, as we had the very same discussion in this country, particularly in regard to marriage lexicon. It's not a marriage, it's a coupling union, or sometimes we lose to say common law unions.
The rights of inheritance and
social benefits, taxation issues, exactly, yes, you could do that, yes. That's a very good point, yes. Yes?
Yeah. I guess I was a little bit astounded by the number of people that you mentioned are affected by this type of laws. You said 1/3 of the world population, so that was a very shocking number for me. And my question is, especially given the current events in North Africa and all this, and how does globalization affect the change? Is it accelerating somehow the change that's probably inevitable?
I mean, yes, I have not been able to see a Facebook revolution in regard to hermeneutic communities, but of course with the use of internet or telecommunication technologies, if you like, there is much more interaction going on across those communities. For example, as many of you may know, there is an international network, women living under Muslim laws, a huge network, and they have been very productive and to effect change from Nigeria to many other countries, for example. As I said, Israeli women are learning and reading examples of Moroccan women, how they've been able to, in 2004, change the Mudawana, for example, make the law more, for example, women-friendly. So that kind of learning across the boundaries are taking place. And this is more visible, of course, among the Jewish groups. For example, as I mentioned, there is an ICAR, International Coalition for Aguna Rights. Women from North America, from Canada, Israeli women are coming together to fight for the rights of Israel, Jewish women specifically within Israel. But again, I have not been able to really see to what extent that technology has been yet used. Hopefully, one day. Yes, please.
Hi. I was just wondering, it was your final slide, I think, when you were talking about the cultural relativism versus Universalist project, and I know you talked about it being a bottomless pit. I actually am a student of a college and I'm a philosophy student, and this is why I look out, so I understand that. But I was just, from the point of view, from your research, could you just maybe just discuss a little further how you feel the Universal Human Rights Project should be interacting with these, is it purely counterproductive by telling minorities and telling them to do making them much more defensive, or is there a constructive way that the Universal Human Rights Project could engage with these kind of personal statuses?
I think that's a very, very good question. In fact, as Anne just mentioned, this in one of the capacities that I've been doing is as a consultant to UNIFEM, UN's main women's agency, to consult them and tell them how to, what kind of intervention mechanisms can be designed to help women under customary and religious legal systems. Again, I would like to distinguish between two types of secular approaches. One is top-down. For example, there's a great example that's coming from 1979 law number 44 in Egypt, where Back then, the president was Enver Sadat, and Sadat's wife, Jihan. She was very feminist. She wanted to give more rights to women, so forced her husband to give women new rights while the parliament was on vacation. And he, with a presidential decree, he promulgated a new law which said having or getting the second wife without the first wife's consent is automatically enables women to seek divorce. That was one of the most progressive divorce laws in Egyptian history. But in 1985, of course, once the law was promulgated, conservative forces, Islamist forces, they mobilized against the law, and they had been able to convince the Constitutional Court that the law was, on technical grounds, unconstitutional, and it was reversed. So that was one of the most important shocks to secular movements in Egypt. That was top-down. But I would like to distinguish bottom-up secular approach, because those secular approaches, you cannot deny their utility. They are, I think, very important. And as I indicate in my own research, hermeneutic communities will never succeed or emerge in the first place unless there is a viable secular movement or discourse in the society. Because hermeneutic communities always their interlocutors. They are the middle ground players, if you like. They play between the religious field and the secular field. And they take those ideals, for example, so-called equality, gender equality, etc., and they translate them into the local context. So in my capacity as a consultant, what I say, for example, you have to identify those hermeneutic communities. You have to build the necessary capacity into them so that they will be able to engage and bring the change. But again, there is always a limit to what you can achieve through hermeneutic. At the same time, you have to continue pressuring through international means. We have CEDAW, for example, conventional elimination of all forms of discrimination against women. So through the state channels, international organizations, you have to pressure state governments to live up to their commitments. But from the bottom up, you also have to identify those communities because they are very important for social change. Unless you change the behavior and attitude of the people, you will not succeed. Let me give you a very brief point. As I said, women's groups were very successful in Egypt in year 2000. They did, through hermeneutic reform, they got a new right to divorce, this Hola divorce. I interviewed judges in Egypt who referred to women who use Hola as sharmuta. Sharmuta is not a very nice word. It means, if I may very loosely translate it, it's just slut. So why the judge was referring to a woman who was just using his Islamic right that was given to her by Prophet Muhammad based upon a hadith? Yes, it's Islamic, it's legitimate, religious authority that Allahs are accepted, but the social change did not take place yet. So you have to really work on that behavioral, attitudinal change at the grassroots level.
Last question.
Yeah, I was
Yes.
Just struck by your very first example about in India, in
Yes.
a Muslim court, I guess, where they brought some pork for the person to eat it. Now, would this be a common practice? I mean, it seems rather bizarre.
Very good question. Number one, it was not a religious court, it was a civil court. And the judges were Anglo-Indian civil judges. And that took place in 1937. Later on, that went to appeal court, and at the appeal, the judges ruled that it was not permissible. It was one of the interesting cases. That's why I shared that with you. However, in recent cases in the 1990s, sometimes judges will again test the person's religious conviction by asking people around if this person, a Muslim, if he attends to mosque on Fridays. There was a case, for example, in the 1990s, a Hindu man converted to Islam. He committed bigamy, got a second wife. Again, the judge had to find out how sincere he was. He asked around. He said, you know, you don't attend the mosque on Friday, so you are not a Muslim. So he was convicted of felony of bigamy under the penal law. Thank you.
A wonderful talk for WSRP. So many of our projects are about these hermeneutic communities, and this Yüksel really put it in context for us. So
Thank you.
you all for coming.
Thank you. I appreciate it. Thank you. Thank you. Thank you. Thank you very much.